Welcome to Anti-Abortion Movements and the Future of Roe versus Wade. This is an event in the Clayman Conversation series, and it's brought to you by the Michelle R. Clayman Institute for Gender Research. Since 1974, the Institute has conducted research, intersectional gender research, and has brought together diverse communities of interdisciplinary scholars, has endeavored to translate gender research to broader audiences. Today's event is as part of that effort. I am Adrian Daub. I'm the current director of the Institute, and I thank you all for being here today. We're here today discussing abortion for obvious and alarming reasons. SB 8 in Texas and the abortion ban in Mississippi have been a long time coming, and the groundwork for potentially overturning Roe versus Wade has been laid over decades. Reproductive justice has, of course, always been of great interest to us at Clayman and as a feminist community, but perhaps never more so than today. While we do want to admit that rage, sadness, and consternation all have a place during this time of upheaval. They have their own political power and legitimacy. We as an institute have found ourselves turning to research and to the expert in this situation. The question of how we got here is both deceptively simple and to answer and extremely complicated. We could not think of two better people to help us think through and speak to this issue of how we got here and where we're going. And we're both deeply honored and grateful to be joined by the brilliant scholars, Melissa Murray and Jennifer Holland, whose work I know I have definitely relied on to make sense of recent events and their broader implications. Let me now briefly introduce our speakers. Well, first, let me say that while we're having a discussion about abortion, specifically from a gender and racial perspective, we are looking to understand sort of the history of activism around this issue and the legal terrain of the current abortion battle. Before I introduce the speakers, let me make a couple of programming notes. Those of you who've been to a few of these will know this, but this is a Zoom webinar, meaning you will need to submit your questions via the Q&A function. The session is also being recorded, so if something moves too fast or is confusing, this will be up on our YouTube channel in the coming days and can be perused at your leisure. And it is also being live captioned, so feel free to avail yourself of that if you need to. The event, as I said, is part of our Clayman Conversation series, which convenes feminist leaders and gender scholars to discuss current events through an intersectional lens. We hope that you will join us for future such events. For instance, our next Clayman Conversation on October 27th at 4 p.m., which is called Silenced: How America's Love Affair with the NDA, the Non-Disclosure Agreement, protects workplace predators. And our guests there will be Gretchen Carlson, Julie Roginski, and Ifeoma Ozoma. And please find more information about that and link for registering for that event at our website at gender.stanford.edu. So without further ado, thank you all for being here today. And now to our speakers. Jennifer Holland is an associate professor of US history, specializing in histories of gender, sexuality, and race in the 20th century North American West. Her book, Tiny U, A Western History of the Anti-Abortion Movement, which I believe is in the chat now, came out in 2020 with the University of California Press. She's also the book review editor for the Journal of Women's History and received her PhD from the University of Wisconsin. And I should say that Tiny U has shaped our thinking at the Institute, not only about abortion, but also about the gendered and racial evolution of social movements more generally. Holland helps us understand how the anti-abortion movement, which in a way emerged as a right-wing mirror version of the civil rights movement, began in kind of highly regionally and socially specific contexts, and then went on to become perhaps the most effective social movement of our time, presenting anti-abortion activists' tactics with precision and historical depth. Holland's book really has helped us think about the growth of anti-feminist movements and the complex gender and racial dynamics within and between these movements. We're so thrilled that you're joining us today, Jennifer. Thank you. Melissa Murray is the Frederick and Grace Stokes Professor of Law and Faculty Director of the Birnbaum Women's Leadership Network at NYU School of Law, and a leading expert in the fields of constitutional law, reproductive rights and justice, family law, and criminal law. Prior to joining the NYU law faculty, Murray was a professor at the University of California, Berkeley Law, and from March 2016 to June 2017 served as interim dean of Berkeley Law. Murray's research has been published in the Harvard Law Review, Yale Law Journal, Columbia Law Review, among other leading law journals, and she regularly provides commentary to a number of lay publications, including the Washington Post and the New York Times. She is a co-author with Kristen Luker on Cases on Reproductive Rights and Justice from 2014, the first legal casebook to focus on the burgeoning field of reproductive rights and justice. She's also co-editor with Riva Siegel and Catherine Shaw of Reproductive Rights and Justice Stories from 2019. Murray is a graduate of the University of Virginia, where she was a Jefferson Scholar and an Eccles Scholar, and Yale Law School, where she was a notes development editor at the Yale Law Journal. Following law school, Murray clerked very relevantly for Justice Sotomayor, then a judge on the U.S. Court of Appeals for the Second Circuit, and Stephen Underhill of the U.S. District Court for the District of Connecticut. Melissa comes to us today fresh, I should say, from testifying in the House Oversight Committee's hearing on abortion on Thursday. We're really glad that you were able to join us today, especially during what I imagine must be an awful and awfully busy time. So thank you to both of you for being here. It's really such a privilege and such an honor to have you, and welcome to our virtual Clayman Institute.
Thanks for having us.
So I think, as I said in my introduction, how we got here is both a well-known story, and in both of your work, I realized that there were parts of it that we either don't reflect on enough or are actually fairly surprising to a layperson. And so I thought maybe we'd start with an overview of the current moment and then dig deeper into what your research lends in terms of legal and historical analysis. Melissa, maybe you could start us off by broadly contextualizing what is happening right now in terms of abortion access and rights, and what we should be paying close attention to in the coming weeks and months.
Sure. So this is not necessarily a new development. The anti-abortion movement, as Jennifer's work shows, is one that has been enormously successful over the arc of the last 30 years. But the anti-abortion movement has been increasingly aggressive in the course of the last 4 years, and that's really because of a change in the composition of the federal judiciary. The Trump administration, although it did not prosecute all elements of its domestic agenda, it was incredibly successful in getting judges on the bench. And indeed, we've heard all of the discussion about the sort of Faustian bargain the Republicans took President Trump so that they could get these judges on the bench. So we have the lower federal courts stocked with conservative jurists that have been vetted by the Federalist Society, many of them for their express antipathy to abortion rights. And then we had this really plum and fortuitous opportunity, as it were, that President Trump had 3 vacancies to fill on the US Supreme Court. One that probably was not supposed to be filled by President Trump, and the other 2 that came along serendipitously. The change in composition was really met with increased fervor from the anti-abortion movement, because for years, at least since 1992's Planned Parenthood versus Casey, they've kind of been in the wilderness. Planned Parenthood versus Casey was the case that was supposed to overrule Roe versus Wade, and famously it did not. Although the court trimmed back Roe's protections in really important ways, it nonetheless left Roe standing, desiccated, hobbled certainly, but standing nonetheless as a precedent. So to the extent it was a victory for reproductive rights, it was a hollow victory, and it wasn't an entire defeat for the anti-choice movement either. But as long as Roe survived, that was a blow to the anti-abortion movement. And in that sense, Roe became something of a white whale that the anti-abortion movement really was sort of trained on and focused on. They've wanted to overturn it for forever because, again, if Roe stands, then that means there is some kind of recognizable and cognizable constitutional right to an abortion, and that can't be right according to that logic. And so now that the courts are stocked at every level, including at the Supreme Court, this really is the moment, the opportunity. And I think we have seen ground forces really move to fill that space. They are no longer interested in chipping away at abortion access, which had been their plan for a long time. They were very worried when Ruth Bader Ginsburg was on the court that if they pressed a frontal confrontation with Roe, they would not have the votes for it. And more importantly, she would be the one in the majority to write the opinion further solidifying abortion rights by adding an equality dimension to the logic of Roe's privacy. So now they are in the pole position. They have a 6-3 conservative supermajority. And the response to that at the state level has been an increasing spate of more aggressive abortion restrictions, more trap laws that trim back access, but more importantly, these laws, like the heartbeat bill in Texas, like the law that's being challenged from Mississippi in the Supreme Court today, all of them pushing on the actual precedents that undergird the right to abortion. Like by their terms, these laws are unconstitutional, but they are efforts to push the envelope on what abortion is. So this is the moment, and this is what we're seeing. What should we look for going further? It's not going to stop at abortion, and they've tipped their hand in some direction. There was a brief filed in the Mississippi case by Jonathan Mitchell. He is the architect of SB 8, the Texas law that bans abortion at 6 weeks. And in that brief, Jonathan Mitchell suggested to the court that not only should they overrule Roe versus Wade and Planned Parenthood versus Casey, but they should also overrule other illegitimate anti-textualist precedents. For example, Lawrence versus Texas, the decision that decriminalized same-sex sodomy, Obergefell versus Hodges, the decision that legalized same-sex marriage, and Griswold versus Connecticut, the decision that made the concept of a constitutional right to privacy a real one and that undergirds all of these rights. So there's a long-term play here, and it will not stop at abortion.
Yeah, I totally agree with everything you said. I mean, the amicus brief from the Texas Right to Life architect was shocking. But of course, it makes sense because all of these rulings are linked together, right?
I think that's right. I mean, again, privacy is the thread that links all of these, and so we are used to thinking about these questions in really siloed terms. There's abortion rights, there's LGBTQ rights, but I think that brief really made clear that our fates are linked, and everything is in the crosshairs right now.
I'm back. Sorry, I briefly dropped out
We
here.
handled it. We took over.
I can tell. Thank you so much. Well, and I think you, Jennifer, you're already going where I was going to what I was going to ask about next. Can you talk a little bit about the development of this and how as Melissa is saying, like it feels like the first of a house of cards. How was that decision made? Has it always has it always been the strategy? How did I think in your book you kind of show how it was kind of a deliberate strategy. Why is that? How did that come to pass? And has that always been a constant? Sort of making abortion access, making the question of choice, sort of the central fulcrum that was going to have to fall, the first card that has to fall in some way.
The movement, the anti-abortion movement, I think is so trained on abortion first and foremost, even though they certainly are interested in all of these other things. But I think that they, at least in their rhetoric for 50 years, they sort of wanted to narrow as much as they could to try to get people on board. But And really, ultimately, their goal from beginning to now is first and foremost to make abortion illegal everywhere, with almost no exceptions. With maybe the life of the pregnant person, maybe sometimes, right? And the strategies varied about like whether that was feasible, right? How to do that incrementally, as Melissa said, or absolutely, right? Those are strategies, but the goal was always to eliminate abortion. But I think that especially the power that this movement has politically, that there's a real history to that this movement starts off, largely as a white Catholic movement, with a couple of other religious people. And then by the late 70s, they're really joined by Mormons, but most importantly, by white evangelicals. And through that, they're growing in numbers and they're growing in power. But I also want to say that the party orientation of this movement is not always clear from the beginning, right? Catholics are actually largely a Democratic constituency when this movement begins, and the anti-abortion movement sort of mixed. The activists, are they Republicans? Are they Democrats? And over the 70s, parties are really reorienting themselves around issues of abortion and feminism, and of course, race as well. And so eventually, the movement realizes like they need a partisan vehicle, and the Republican Party comes out as the one that's going to be the vehicle for their politics, that they are committed to, to this kind of, putting abortion first. But for many years, Republicans say the right things, but don't do anything. They don't do much, right? Ronald Reagan is a great example of that, right? He's the governor of California. He signs this abortion reform bill. He's got this foot in this older Republican Party, and yet he runs on being an anti-abortion candidate when he runs for president. And when he has a Supreme Court slot to fill, the Right to Life movement says Sandra Day O'Connor is not the candidate, right? She is not. Arizona Right to Life says this is not our guy, and he ignores them, right? So he's a perfect example of someone who doesn't actually pay out, even though he's got the support. But that really changes, I think, around the 21st century. You have a lot of, family values, anti-abortion, people sort of putting their foot down and saying no more. We have to, you actually have to pay out, in terms of legislation, in terms of justices, in terms of court, right? You have to be actually doing this. And I think that, over in the 21st century, one of the reasons we see this incredible amount of change is that finally, not only do the anti-abortion activists have a party, but they have a party who's is staffed with activists too, or people like Donald Trump who know where their bread is buttered.
So, I mean, I know in your book you write that it's not the story of the anti-abortion movement of the Republican Party is one of sexual moralists who found their party, and so I guess you could say the second stage is then that they essentially take over that party, that they become that party. Melissa, you've written, about the kind of racial dimensions of this, erasing of Roe. Is that an important aspect to understanding what is going on currently around the Supreme Court? What's the relationship between gender and race in the current debate over Roe, and what are the sort of key moments there that we should know about?
Sure. So let me answer the question with relation to what Jennifer just said. Another critical point in the evolution of the anti-abortion movement is not simply fixating on the Republican Party as the vehicle and the Republican Party sort of perfecting itself to be a worthy vehicle, but also a shift in rhetoric around abortion. And, from the Reagan era forward, it was really focused on this idea of the fetus. So the photographs of the fetus as a life itself, and they in time recognize that it's putting people off, like that you're basically treating the woman as a host or a vessel and completely ignoring her needs. And so then they shift into a more woman protective posture. So this is the era of love them both. And, we see the laws being framed in terms of maternal health and women's health. And that becomes a more palatable message. And I think it dovetails with the Republican Party sort of shifting. It's not part of why they are able to sort of sign on wholeheartedly to this message is that the message changes and becomes more palatable to a broader range of people. And so you see women themselves being harnessed in the service of this message. This is a movement, I think, whose rhetorical sensibilities are constantly shifting and evolving in really important ways. And what I see as the next move, and one that is really gaining steam, is a shift toward thinking about abortion as a form of racial justice, sort of tapping into this broader societal interest in racial justice. I saw this very much in the hearings that I attended on Thursday. Lots of Republicans talking about Black women, even though I reminded many of them that they had voted against Juneteenth being a federal holiday, a very minor and symbolic expression of fidelity to the Black experience that they were unwilling to undertake. They've also voted to limit TANF benefits and to not expand Medicaid. But they were all talking about their concern for Black women who have been unwittingly duped into aborting the future of the Black community. The argument that I make in Racing Roe focuses on a concurrence that Clarence Thomas offers in a 2019 case, Box versus Planned Parenthood of Indiana and Kentucky. And it was a pretty sort of minor case on the court's shadow docket, which has received a whole lot of attention these days. But basically, the court denied cert as to a request to review one aspect of an Indiana abortion law. And then it granted another petition to do on a different law and ultimately upheld it. But with regard to the provision that they denied cert on, this was a trait selection law, a reason ban that prohibits abortion if it is undertaken for purposes of sex selection, race selection, or because of the diagnosis of a fetal anomaly. And Justice Thomas wrote this concurrence telling his colleagues that it was fine to pass on reviewing this law for now, but the time was coming when the court would not be able to avoid its constitutional duty to speak on this question of first impression. And then he took another turn and he noted that these kinds of trait selection laws were merely the state's modest attempt to prevent abortion from being a tool of eugenic manipulation. And then he proceeded in a quite long and lengthy and historically inaccurate opinion to graft the history of abortion to the history of the birth control movement and Margaret Sanger's affiliation with the eugenics movement of the 1920s and 1930s. And to be very clear, Margaret Sanger was in league with the eugenicists, but she was also violently opposed to abortion. She believed that contraception provided a better way and was a better alternative to what she termed a surgical alternative, abortion. More importantly, the eugenicists were not interested in abortion. Their interests in white supremacy, racial purity, were channeled into laws that prevented certain populations from entering the United States as immigrants, laws that banned interracial marriage and miscegenation, and more importantly, laws that required the forcible or coercive sterilization of those who had deleterious genes that could then be passed on. To the extent abortion figured into their plans at all, it was really in the other direction. The interest in criminalizing abortion arises in the period after the Civil War, when the white native birth rate is falling relative to the immigrant birth rate, which is rising and quite quickly. And so the interest in criminalizing abortion is to compel native-born white women to have more children so that the demographic character of the country can be maintained. All of this is absent in Justice Thomas's narrative, in part because it has to be to fuel this idea that Roe's founding moment, its originalist moment, is not in 1973, but rather in 1923. And therefore, it is a tool of eugenics, a tool of deracination, a tool of Black genocide. And that's the argument that they are proceeding with right now.
And as Jennifer's work points out, that's actually this relationship to the civil rights movement, the co-opting the language of the civil rights movement, is something she traces in the very beginnings of this. So there's something really coming to fruition almost 40 years later, 50 years later. Is that correct, Jennifer?
Yeah, yes, this is, they evolve. And I think the fact that Clarence Thomas is making this claim is distinct, right? That a lot of these are everyday activists who are trying to sell a particular historical narrative for a long time. But I think it matters, especially when you have the Supreme Court actually buying into these long stories that white religious conservative people tell about their relationship to slavery and civil rights, and also the Jewish Holocaust, right? That's like in there. They're working this out right early on, but I think you can actually see how they're not quite sure about their relationship to civil rights just right before the movement in a lot of these anti-birth control debates, because they come like they're trying to think through what their relationship to Black people is, and they're not committed yet to being akin to civil rights activists or to abolitionists. That you have Catholic intellectuals being like, actually, they're saying they're akin to maybe the white Southerners and the federal government, right, coming in and taking their rights during Reconstruction, right? This lost cause narrative. They're playing around with that idea alongside thinking about themselves as akin to or an extension of civil rights activists. But I think by the time the anti-abortion movement's born, they sort of decided where the moral currency lies, and the civil rights movement is being sort of pacified in American memory. It's becoming righteous, but in a whitewashed kind of way, and they grab onto it. And so very quickly they're comparing Roe to Dred Scott, right? Like that's very early. They're sort of making that comparison, saying that Roe versus Wade dehumanizes people in a way that Dred Scott, right, the 1857 case that ruled that African Americans were not full citizens of the United States, or they're saying there's something similar, right? Some dehumanization going on, and they move with that. And I think it matters that these are white religious conservatives co-opting that way, right? I think this group is overwhelmingly white. I mean, distinctively white. I found a handful of people of color participating, but this is overwhelmingly a white conservative movement. And I think that they're borrowing in this very superficial way, in a way to sort of recenter the morality of whiteness in the aftermath of the civil rights movement. That there's a wrestling around what it means to be white and what it means to be conservative after that. And I think that trying to grab hold and co-opt the struggle of Black people for their own, right? It recenters their own morality, and allows them to talk about themselves as abolitionists, but also white people as victims, right? Because fetuses are victims, and they often figure fetuses as white, but also they tie their own identities to fetuses, and then white conservatives become victims too. And so it's a very compelling combination for a specific group of people beginning in the 1970s on. And, I think that when Melissa was talking about the ways in which this has been sort of captured in some of these bills recently, I think is just sort of overwhelming. The idea that someone could even have the gall to suggest that like women of color might be committing genocide on themselves or something by having abortions. It's just sort of beyond the pale, but actually makes a lot of sense if you understand the anti-abortion worldview.
Can I ask about something that I found kind of noticeable here, and maybe I'm lumping together things that shouldn't be lumped together, but correct me if I'm doing that. I think you've both drawn to the kind of the reactionary and kind of and repositioning whiteness as victimhood aspects to this movement. Is this also why what we're now seeing are kind of, there are no real victory laps being taken, even though they seem to be scarily close to getting what they have said for 50 years that they want. I guess I would put, I don't know which category I would put Susan Collins into, because I have no idea what on earth she's doing, but there are definitely people who have been explicit in the fact that they would like Roe to be overturned, who are extremely muted. And I could never figure out if this is about it. I mean, I'm sure it's also about tactics, but is there also something of that in some way there was a lost cause narrative behind it, and in some way it was never, the movement never understood itself as being able to actually impose this. Does that question make sense? It's something that you said that both drew attention to, that I think I had never put together like that before for myself.
Well, I think I'd just like to hear a little bit more about who are the anti-choice politicians who are mute right now. I guess it's true that Susan Collins isn't saying much right now, but I also think of her as, in the same way, Sandra Day O'Connor, when she was nominated to the court, was sort of a dying breed of kind of waspy Republican, and the party was changing all around her, which is part of why she was found to be an unsatisfying choice for Ronald Reagan, who had placed himself firmly in the camp of the evangelicals, even if he wasn't playing that role all of the time. But, I sort of think of her as a kind of classic New England Republican at a time when that is not really the face of the Republican Party. So while she is mute, I don't think many of the others are. The Senate Judiciary Committee hearing that we had earlier last week was full of fire and brimstone from people like Josh Hawley and Tom Cotton and Ted Cruz about Roe and abortion rights and the court, and whether or not progressives who were championing reproductive rights were trying to intimidate a coordinate branch of government. I mean, that by itself is sort of a wild statement.
Right.
Someone from this sort of wing of the Republican Party talking about how bad it was to intimidate a coordinate branch of government. But, there you are.
Yeah, I think that they're thrilled. I also think that I do think that no one is quite prepared for what it's going to be like, even if they're thoroughly excited that it will be. But they have been in the minority for so long. I am interested in what does an anti-abortion movement and what do anti-abortion politicians do once abortion is illegal in half the states? I am fascinated by what happens then.
Then you move on to sodomy, and same-sex marriage, and eventually maybe you make your way back around to Brown versus Board of Education.
Right. Well, and they cited Loving in that decision too, right? In that, or not in the decision, in the amicus brief.
Yeah.
But I mean, being faced, right, with what it might actually look like, because like Melissa said, activists have been selling that making abortion illegal will be good for women for a while. And they keep hiding the fact that it doesn't actually make a lot of sense,
right,
to call abortion murder and then not call women murderers. That doesn't actually make a lot of sense. But they keep trying to avoid that. But once states start passing all these laws and women start getting caught up in much larger numbers than they already are. I mean, women are already getting caught up in the law criminalizing women in pregnancy and pregnant people. But how do they react to that? They ignore it, maybe. But I'm interested in what the next step will be. I think it will look different than what it's been.
It's part of, I think, the difficulty. And again, Adrienne, this is a different take on your question. Part of the difficulty, I think, is that they understand that abortion rights enjoy widespread acceptance among a broad swath of the public. 70% of people in the United States believe that there should be a right to terminate a pregnancy. They may differ as to what the nature and scope of that right might be and when you can exercise it and on what terms, but they are adamant that the sort of underlying core of Roe, that there is the right to terminate a pregnancy, is and should be constitutionally recognized. So there is a way in which this entire movement and the fact that they're about to achieve this is really the triumph of a minoritarian brand of politics. And if you think about it in that way, we shouldn't just be worried about abortion. What we should be worrying about is like, those are like the creeping signs of authoritarianism. And maybe what we're really seeing is sort of not just the nationalization of women's bodies, but the nationalization of women's bodies in the direction of a particular political project that doesn't just end with abortion, but is actually about dismantling the entire system of representative majoritarian government. I mean, that sounds like hysterical lady parts hyperbole, but I don't know how you can't view it in that direction.
Yeah, I mean, I do think it's noticeable that there is that as democratic institutions fail, this movement seems to be having one success after the other.
And it's having that success in a minoritarian branch of government.
Exactly.
It's not something they could do in Congress, although they are doing it in the state legislatures, mostly because courts have allowed them to redistrict and to suppress votes and to create legislatures where this would be amenable and indeed desirable.
I mean, one of the interesting things that the way, especially both of you have been talking about the question of activism in this. There is something really interesting in the way that SB 8 in Texas, of course, kind of empowers activism, right? It is in some way it's in some way making anti-abortion activism a law, right? In an interesting way. Can you talk about that a little bit? Like, I guess it was often thought about in terms of like, of vigilantism, but it is also just a form of legislating forms of surveillance that this movement has sort of practiced for years now.
That's interesting. So specifically, the law SB 8 is different from other heartbeat laws, even though it's substantively the same procedurally. It's different because it doesn't commit the enforcement of the law to state officials. Instead, it delegates that to private citizens in the sort of vigilante style bounty hunter system that you've alluded to, Adrian. And I had not thought about this as a kind of basically committing into legislation the kind of surveillance of vigilantism we've seen around clinics, for example, clinic entrances and things like that. But that is surely correct. But at bottom, it is a very canny legal strategy that was dreamed up by Jonathan Mitchell, the same person who is trying to also invite the court to overrule Lawrence and Obergefell and Loving and whatnot. But it was designed to purposely evade federal court review, because in these legal challenges, the name of the game is not necessarily having the law upheld. They know the law is not going to be upheld under the existing precedents. Like, the law is patently unconstitutional. What you want to be able to do is to get the law on the ground and working until it is determined to be unconstitutional. And that typically can't happen because when the laws are enacted, the abortion providers immediately sue the state official who's charged with enforcing them, and the laws are immediately enjoined because they are patently unconstitutional. And so what they've done here in Texas is, by taking the state out of this entirely, delegating it to private citizens, they've basically created a framework where you can't find a universe of defendants, or you can't identify the universe of defendants such that you could prevent the whole law from going into effect before it is actually challenged and its constitutionality is determined. So it is incredibly canny, and it's done what no one else has been able to do, which is to basically bring abortion access in the second most populous state to a crashing halt.
Yeah. I also had not thought about it as akin to sort of the clinic violence that is still around, but was so common in the 80s and early 90s. I think this makes it more pernicious, but I think a lot of that kind of threatening violence was the threat of extra-legal violence, right? That they'd take a picture of you, of your license plate, that they'd follow you to your home, that they follow to your kids' schools, right? These were common tactics. But it wasn't per se that they'd call the police, right? Or that you were breaking laws. It was that they were threatening to break laws against you.
Right.
and that they would have some sort of record. And of course, famously, they had lists, or someone had lists, right? A hit list to terrorize people. But of course, SB 8 gives them the power of the police.
Yeah. At the same time, you point out in your work as well that there is, in some way, the more spectacular aspects that I guess we sort of think of, especially in terms of, I guess for me, I would think the high watermark sort of the 90s when that really becomes, that is the face of what people think of when they think of sort of radical anti-abortion activism. That in some way, if I understand your argument correctly, there's actually, the everyday stuff is far more pernicious. In some ways, it's almost like the shiny object that distracts from the much smaller bore things that are done. Can you talk about that a little bit more? Was that explicit in the anti-choice movement, or is that more in hindsight that we can sort of say that?
Well, yeah, I think that so much of our conversation about abortion sort of depends on what crisis we're in the middle of.
Right.
And now it's so much revolving around the court because, of course, of all the changes that Melissa's spoken about. But yeah, in the 80s and the 90s, it was largely about radical activism, about Operation Rescue, and a whole host of other radical groups, right? Blockading clinics, and also, a violence of various kinds, including murder, famously. Right. But I think that, yes, I think that particular movement had a moment, and I think people were so centered on that. And I don't think that moment was actually productive of anti-abortion sentiment, right? It didn't sort of lead us to understand now or understand all of these sort of moments in time before now that the right to abortion has been eroded, or where people sort of commit themselves to a politics where ending abortion is the only issue, right? Is the issue. That you don't care about anything else. You don't care about tax policy. You don't care about someone else's. Even there are other moral issues, right? As again, Donald Trump was a glaring example of. And so I really, when I looked at this movement over the last 50 years, where I saw that kind of most productive work for this movement, where they sort of waged their battle for hearts and minds, was in these intimate spaces of people's lives, that they came into their church spaces first, right? And said, gave their presentations and said, religious people, there is a religious perspective on abortion, and that is abortion is murder. That was a political claim, right? That was not true then. It's not true now.
Right.
Clergy had been helping women access legal abortion very vocally, very overtly. But you have anti-abortion activists come in and say, your relationship to your God is like partly revolving around thinking about the fetus as a life, and abortion as the biggest problem going on. And then in the 80s and 90s, they spread that out and started going into kids' schools and going into their homes and really putting a lot of effort into crisis pregnancy centers, like meeting women in these vulnerable places of their lives, and a whole host of family values politics. And I think that that's where they did the most successful political work, right? Getting white religious people to center their identities around defending fetal life and ending abortion. I mean, if anyone doesn't know about crisis pregnancy centers, you will, if you ever look, because they're everywhere. Almost every single community has them. Like abortion provision is almost nowhere. But if you want a free pregnancy test, or now ultrasounds or STD tests, right? You have basically an anti-abortion political center that will give those to you, and also a dose of anti-abortion ideology and maybe some goods to help you out with this baby. I mean, and so there's those places I think often go unnoticed, but they were so profound in terms of political transformation.
Well, they're not just profound in terms of political transformation, and they become so important, as you say. They're also cited in minority communities, like basically the same playbook that they have accused Planned Parenthood and Margaret Sanger of doing. This idea that you are citing abortion clinics in minority neighborhoods for the purpose of racial genocide, and you're seeing the same thing, only from the other direction.
Yeah, I've found this to be the case around issues other than abortion too, that the amount of projection, the amount of work that is done by projection in these movements can be really quite tremendous. And the way that often kind of a concern with protecting someone and this kind of unspoken thing that you're protecting them kind of from themselves, that those are often very closely linked in the language here, that paternalism of some kind is extremely important there, right? The language of regret, which I guess is no longer that front and center to the kind of effective tropes that they deploy. But I feel like it was always the big was one of the big quivers and arrows in the quiver sort of in the 90s and early 2000s, right?
Yes.
So is there anything, and so I think we're talking about how these things that you've both been tracing in the last 50 years are sort of coming to fruition in this particular moment. Is there anything that surprises you or gives you hope or makes you even more worried, right? Something that where this isn't exactly the way you thought this was going to happen, or you thought this was, or where you think that there may be still, where we may still be surprised in the next couple of, right? I mean, I think, Melissa, you put it most starkly with like, well, they're coming for that next, and I hear you on this, and like, I could easily see us talking about this in 10 years and being, yep, that was pretty much the list. Are there any things here that our viewers should think about, that might give pause at least?
Yeah, one thing that I think is really interesting in terms of a development is this idea of the whole life movement, and the whole life Democrats specifically. And so this is a group of individuals who are sort of nested within the pro-life movement. They are largely evangelical. They are very much anti-abortion. They're also mostly African American and Democrats. And their whole point is that they are pro-life, but for the whole life. So their antipathy for abortion is also matched by an antipathy for the death penalty. It is also matched by an interest in rooting out state violence against Black people. They are in favor of reforming qualified immunity. They are in favor of expanding the social welfare state. They are in favor of expanding access to Medicaid. They are very troubled by the high rates of maternal mortality in many of the states that are most fervently anti-abortion. And similarly, they are troubled by high rates of infant mortality in some of these areas. And so in a lot of ways, their rhetoric mirrors the rhetoric of women in the Black Power movement in the 1960s. So, as the men were talking about the prospect of family planning being a tool of racial genocide that the man was pushing on the Black community, there were women within the movement who were saying, we actually want birth control. We want to be able to plan our families because we're the ones raising these children while you're, out doing whatever it is you do with the Black Panthers and whatnot. And the conditions in which we are raising our children are terrible. So, there is a kind of reproductive justice and redistributivist ethic to this whole life Democrat movement. And they nest very uncomfortably, I think, within the pro-life movement. And so one of the things I think I'm actually quite interested to watch develop is how these two aspects of the anti-abortion movement come together and coexist in the pro-life movement going further, because the commitments that they have beyond abortion are very much out of step with traditional conservatism. This is about a complete reimagining of the welfare state and the role of the state in relationship to the lives of people of color. And that, to my knowledge, is not something that's on the agenda of most of the pro-life movement. So it'll be a really interesting coexistence to monitor and watch.
Yeah, I think if I had hope, and it's not a thing that I do a lot now, but I do have hope for a grassroots reaction to this. And I think that the reproductive justice movement is so big and diverse and thoughtful on a whole host of things. And they have, like this group, famous reproductive justice group, Sister Song in Georgia, right there, they've already been a part of, for example, Swinging Georgia Blue alongside a whole host of other groups, right? They're already they're sort of doing work on a whole host of ways in protecting democracy. And I hope that that movement that's already there can sort of help lead a reaction that incorporates people who are going to be most affected by making abortion illegal, alongside people who are very privileged. And I hope that and there was some moment in the late 60s where you had sort of, like I said, like a lot of clergymen who were speaking up, and testifying to legislatures. And I hope that the reproductive justice movement will be able to sort of lead with a whole host of people, both those who are going to suffer in serious ways, alongside people who aren't, but hopefully see the stakes of this.
Yeah. So I think we should, we have some great questions in the Q&A that I'd love to get to, but I sort of because you brought up the question of suffering, right? So we, part of how the discourse around abortion was changed in the 70s was, of course, according to the old feminist maxim that the personal is political. And one of the things that I've found kind of remarkable is that it does seem that ethos has kind of hit a limit with these most recent laws, in the sense that that somehow the politicians who put these forward seem to be able to just ignore the very real suffering that they're kind of casually inflicting, and instead talk about the evils is being done to fetuses. Does that change the calculus? Does that mean that if it were to become necessary, I guess it's already necessary, but does that necessitate a change in tactics from sort of the first go around of this, like the first attempt to to establish reproductive rights, give it more firm basis in law and in the Constitution, or do you think that in some way these groups are just hewing to very old principles and showing that they're still very valid?
Could you say that again?
Sorry, I'm just asking about the fact that the suffering of the question of who's suffering under these laws really is being kind of abstracted away from the discourse around them in some way, right? Like, in the case of the different, Indiana and Virginia and whatever the ultrasound laws, et cetera, the argument was always, imagine if that were happening to you, and somehow that entire movement has been able to sort of inoculate itself against that bit of moral imagination, where you sort of have to you don't have to place yourself in that position anymore. Is there promise in reactivating that, or does that mean that new tactics are required? I guess is what I'm wondering here.
Well, so can I ask a question, or maybe complicate it a little bit? I mean, it's true that you're no longer being asked to imagine yourself in the position of the woman seeking an abortion, but being unable to get one. But I think one of the things that they are doing, especially by sort of prosecuting this idea that abortion is a form of racial injustice, is to allow the individual who is pro-choice to imagine himself or herself as someone who is kind of a savior of not just fetuses, but also Black people. And maybe that's incredibly heady at a time when, we are really thinking about what it means to stand up to and to protest against the prospect of violence against Black bodies, whether it's by the state or by others. And to be clear, they are talking about abortion rights as a form of state violence. The very fact that Roe exists is the state facilitating this kind of violence. And so it's sort of Shelley versus Kramer, or a sort of passive facilitation, but it is a different kind of state violence nonetheless. And so it allows everyone within that movement to imagine themselves as a kind of white savior.
Interesting. Yeah, and I mean,
Yeah.
we have, go ahead, sorry, Jennifer.
Yeah, I do wonder though what's going to happen, because certainly so many people have gotten caught up and not been able to get abortions with the wild maze of abortion restrictions. A lot of places already have, red states where I live, right?
Right.
And yet that is going to go up a notch. And are they going to be able to ignore not only people leaving the state, but of course, places like Oklahoma are going to pass laws saying you can't leave the state.
Right.
And maybe people crossing state lines, right, are going to be criminalized to seek abortions. And so once the state borders are being manned, to catch people going to seek abortion, I don't know. Is that imaginary of themselves as white saviors, abolitionists, whatever, is that going to be able to still eke itself out above that kind of execution of state of sort of criminalizing a whole host of people? I don't know.
Or maybe it leads to, again, taking your abolition metaphor to the next level, maybe it results in a constitutional amendment that enshrines the notion of fetal personhood, and then you don't have free states, slave states. You just across the board have a situation where abortion access is not permitted at all.
Yeah, and I
Canada.
Yeah. Yeah, and I guess I realized that on some level, my question was, if people actually start going to jail, well, people are already going to jail for this, but if it's in significant numbers, wouldn't that lead to outrage? And I was like, wait, I'm asking whether the American public would lay off punitive measures because a ton of people are in jail. I'm like, wait, I just heard my own question, and I realized that was a very historical idea. But I guess it does. I guess I am still thinking about the question of rhetoric here, and just what the next steps need to be. But maybe we'll leave that and start going to because you've already mentioned this idea of a constitutional amendment. Someone asked the question that I was like, oh, I don't know the answer. An anonymous attendee asked, if the ERA were passed, would this protect Roe v. Wade? And I don't know the answer to this, and we have the expert here. Would it?
Unclear. One, there are, I think, a host of questions about the ERA and its legitimacy in its current form, having recently been ratified by the last remaining state. There are lots of questions about whether that ratification is sufficient to include it in the Constitution. I think the whole question, though, sort of raises what I think is a quite difficult conversation that's currently happening within progressive communities about how to talk about pregnancy, abortion, pregnancy discrimination, and how to marry discussion of those things with a discussion of LGBTQ equality on the other hand. So, we've talked today, and we've both used the term pregnant persons. Sometimes I've toggled back and forth and talked about women. I think at bottom, the ERA reflects the constitutionalization of the notion that gender inequality, gender discrimination is not permissible, but the way it has been understood, it has been about women's inequality, sex-based discrimination against women. And, so if we start thinking about abortion, I think in terms of everyone who is prohibited from getting an abortion, and that could include individuals who are trans persons, then, maybe it is harder for the ERA to reach that. But I think this is just a bigger question for progressive movements to think about. What does it mean to be both inclusive, but also to highlight the degree to which the nature of the problem is actually a species of, in this case, sex-based discrimination. The way that these states are talking about abortion restrictions, it is about compelling a particular identity, motherhood, on individuals. Right. And that's very sex specific. And so, I try to sort of marry the two by speaking in some cases in terms that are gender neutral, but also nodding to the fact that this is a species of sex discrimination. Pregnancy discrimination and abortion restrictions are both species of sex discrimination, and we have to understand them in that way as well. So to me, that's the big question with the ERA, and like leaving aside the other big questions of whether the ERA is legitimately ratified.
And I also think that, I don't know what it would be in the 21st century, but if we look at the ERA debate as it was, partly because this is happening at a moment when the, sort of religious right is rising, and the pro-ERA movement is getting like pushed and pushed to narrow what this thing would do. They keep saying it would not expand or protect abortion access, and it would not protect, they say, no, lesbians won't be able to get married. Like those two things are the things that they keep saying the ERA will not do. However, a number of states passed their own equal rights amendments into their state constitution, and there is one state that interpreted it to protect abortion access, and that's New Mexico. So New Mexico has a state ERA, and their courts have interpreted it to say that it does protect abortion access, but none of the other states that have their state ERAs.
Interesting. Well, so one of the states that you write about in your book, in fact. That's incredibly. It's incredibly heady too, right? That in some way where the ERA sort of comes to us from an era that is maybe not best positioned to guide us here, partly because this is clearly meant to enshrine sex roles that no longer really conform to how we understand gender at the present moment, and that's going to be a really interesting question around activism as well, isn't it? Can I ask? So we had one question come up that's absolutely just straightforward. Whether there's any chance that the Supreme Court will make a decision on the Texas ban. Philippe asks.
So I think we will see this case come back before the court, maybe even as soon as the next month or so, something on the shadow docket. I think the real question here is there going to be a set of identifiable defendants that are available to confer standing such that the court could then reach the merits of the case? Like, remember, the Supreme Court refused to get into the question of whether the law violated the Constitution because the procedural irregularities prevented it from even speaking on the question in the first instance. So, I'm not sure if that is obviated. I think the best vehicle for that is likely the Department of Justice's suit against Texas, but that too raises really thorny questions about standing and whether or not the DOJ has standing, but the DOJ definitely has the best footing to make those arguments and certainly to enjoin the enforcement of the law throughout the entire state. With the other defendants, it's sort of a more piecemeal journey, like you're enjoining as to this lawsuit and then as to that lawsuit, but not necessarily enjoining the whole law against the entire universe of potential plaintiffs and defendants. So yes, I think it is likely. The real action, though, and it's gotten lost in a lot of this, is what's going to happen at the Supreme Court on December 1st when the court takes up Dobbs versus Jackson Women's Health Organization, which is a challenge to the Mississippi 15-week abortion ban. And, everything kind of turns on Dobbs because Mississippi has explicitly asked the court to overrule Roe and Casey. And even if the court does not take them up on that invitation, simply upholding this Mississippi law and saying that viability is no longer a salient concept in the court's abortion jurisprudence will have seismic effects on abortion access throughout the country. It will kick all of these laws, these 12-week laws, 10-week laws. We'll be trying to figure out if those are permissible now under this new constitutional landscape. And so that's a critically important question. I'm not sure if they're going to overrule Roe. That decision would be made just months before the midterm election. And I can imagine the Chief Justice does not want to send American women to the polls with Roe's death on their lips. But a more minimalist decision would also have enormous repercussions. And it is also worth noting, in just the time period in which the Texas 6-week ban has coexisted alongside the Mississippi 15-week ban, the Mississippi 15-week ban, which is patently unconstitutional, actually is now beginning to look reasonable. So the Overton window as to what is okay, what is moderate, what is reasonable in terms of abortion restriction has shifted in just the space of a month.
And meaning it's also kind of a, it gives the Supreme Court also an out in terms of, yeah. One thing that it had just never occurred to me is that the standing issue, of course, is in a strange way the opposite problem that opponents of same-sex marriage always had, that they couldn't really articulate why they had standing. And so now it's interesting that these two, and I think both of you are making me think of these as kind of bookends, or somehow, you know, much more related than we tend to think. And they are in the question of standing as well, aren't they?
I think, like, often there could be there was a state official who was preventing them from marrying by refusing to issue the license, or by enforcing laws that required marriage to be a strictly heterosexual institution. So, you know, there was always a state actor. That's not the case here. But there were lots of people, Justice Thomas among them, who discussed this in terms of, you know, the right to marry that the plaintiffs seek access to is a right against government infringement. They're actually seeking an entitlement, which seems more like a positive right. So I think he often pressed that distinction.
Interesting. So one question that came up in terms of solutions is about the court again, and the question of adding more justices. Is there can we balance the court? This anonymous attendee asks, and I'm guessing the answer is something like yes, but that's not going to happen.
You know, right now there has been a Supreme Court commission that's been struck by President Biden to basically examine the question of judicial reform, broadly speaking, not simply court packing per se or structural reform. It is a commission with 35 people. So, you know, you're on faculties, you've seen what committees of 35 people do. Unclear whether it's going to actually come up with a set of recommendations around which there is consensus. You know, but I think it's really important that people on the ground are talking about it, because again, talking about court balancing or restructuring or whatever makes clear that the people writ large think that something is off here, that the court is perhaps ideologically or politically captured, that this isn't what it is supposed to look like. And when there is that kind of public pressure, you know, the court is supposed to be above politics, but it has to keep in mind what is happening on the ground, because its legitimacy depends on the people believing that it is above the political fray. I mean, I think the fact that something has gone off kilter here is evinced by, you know, this tour of justices hitting the circuit over the last week to tell us that they are not partisan hacks, that they're not doing anything wrong on the shadow docket. It's a little bit, you know, the lady death protests too much, methinks. And I think everyone is getting it. And so to that extent, it is actually very helpful, I think, to have the conversation happening, even if it's not going to go anywhere.
I see. This is a very, very technical question, but I do think it gets at this question of what the wrangling is going to look like in the next couple of months. Regarding the Texas law, why do you think the anti-abortion groups have decided not to bring suits against providers? For instance, the one who wrote the op-ed, whereas two disgraced lawyers have. I didn't know about that there was one even, but,
well, Texas Right to Life sent out some guidance basically saying, don't sue anybody, like don't sue any providers. In part, I think they don't want court cases because legal challenges provide an avenue into some kind of inquiry into the law itself. But the point of this was like, it was never, the point was never to have this law upheld. They know the law won't be upheld, like unless Roe versus Wade is literally struck down. The law will not be upheld unless that happens. The plan was always to avoid federal court injunction so that the law could go into effect, so that abortion access can be hobbled. And so right now, it's check, 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 mission accomplished. We don't actually need to bring lawsuits. We've chilled abortion provision in the state simply by having this hanging over everyone's head.
Right.
Yeah, I mean, I think that it is like a weird snapshot in time because abortion providers are, enemy number one. People can't, the anti-abortion movement's constantly wrestling with who the villains are. Are they women? Are they not? But abortion providers are always, number one. So I think it is not indicative of not, a general trend away from sort of focusing on.
Right, it's tactical, not strategic or something like that, yeah. There's a question about the likelihood that the court would just reduce the standard from undue burden to rational basis. I'm reading the question, and I'm trying to, you may have to explain to us what that would even mean, and then explain what the likelihood is. I'm sorry, I wish I were a lawyer.
It's not too late for you, Adrian, and you have a fine law school there that you can go avail yourself of. So basically, when Roe was first announced in 1973, the court afforded restrictions on abortion the same standard of judicial scrutiny that attended all fundamental rights, which is strict scrutiny, meaning it's a very hard standard for the government to meet. You basically have to show that there is a compelling governmental interest and that the law is narrowly tailored to achieve that interest. In Casey, the court, again, to sort of nod to the state's interest in abortion regulation, lowered the standard of review from strict scrutiny to the undue burden standard, which says that a law cannot withstand constitutional scrutiny if it has the purpose or effect of placing a substantial obstacle in the path of someone seeking an abortion. So not quite as rigorous as strict scrutiny, and is intended to sort of balance the interests of the state against that of the individual. And all of these are balancing tests. What Tina has noted in the chat is, the lowest standard of review, the one where the government more likely will prevail because it is so deferential, is the rational basis standard, which says that a law will withstand constitutional scrutiny so long as it is rationally related to a legitimate governmental purpose. So, very broad terms, very easy to satisfy. And so the idea here is that, another sort of seismic shift in the court's abortion jurisprudence would be for the court to say in this Dobbs case, we're not using the undue burden standard anymore. We're using rational basis review because under that standard, the state almost always prevails and abortion laws would almost always be upheld.
And what would that mean for the cases going forward? I mean, would that change? I mean, I guess we don't want to tell them what to do, but how would that impact the strategy going forward for anti-abortion forces?
Then you just pass more laws because they'd all be upheld, because as long as you can sort of proffer some legitimate state interest for an abortion restriction and there's a rational relationship between that interest and the law itself, you would win if you were the state. So you'll see even more of these heartbeat bills and they would be even more aggressive.
Jennifer, can I ask really quickly, I mean, just going off of this question, when did, what's the relationship of this movement to legal sophistication, right? What is the, what's the, if the end goal was clear, and if Roe sort of became then the thing that they positioned as their Dred Scott, have there been waves of kind of legal strategy here? And someone in the chat, Melinda, mentioned the fact that this is, of course, also frequently a fundraising tool. Like what were people funding? What's the history of these challenges?
Yeah, I mean, the anti-abortion movement has been sort of throwing laws against the wall since the beginning. I mean, at first, they're really focused on a constitutional amendment. That's sort of a hope for a little while, and that sort of dies. But then there's all sorts. I mean, these are the kinds of laws that some of which were upheld in Casey, right? Like parental consent, parental notification. They try at some point to get like sort of father consent briefly. I mean, and so a lot of them are sort of struck down. But Casey's one of those that sort of sustains Roe, but also creates this sort of undue burden, some of which, are constitutional after that. Some of these kinds of practice these laws that they've been sort of trying out to limit access, informed consent, the viewing fetal ultrasounds. I mean, just a number of these kinds of laws. And I think it has been a fundraising tool. I think that has been, especially as you enlist more and more people who are committed to this, they spend their money and their votes. But I also think that sometimes, especially with social conservatives, I think there's a desire to think of them as somehow moneyed and thus inauthentic as social movements. And I think a lot of parts of this movement often run on shoestring budgets for a lot of the time. And then, weirdly, sometimes this movement gets federal dollars, starting in the late 90s and early 2000s.
Right.
Their access, like abstinence only education money and things like that. But there's a lot of money in the Republican Party, and I don't know that anti-abortion, I think the heart of that is less money, more votes.
Mm-hmm.
But of course, it is a fundraising tool. And I think that Melinda also points to birth control, which I think is not going to be, which is going to, a lot of that's going to get caught up in some of these laws, because anti-abortion activists believe the IUD is a abortifacient.
Right.
And so I think it is going to, and of course that will affect even more people, women and pregnant people, right?
Right.
Not just those seeking abortions. And will that be as good an organizing tool, as good a fundraising tool? I think surely not.
Well, especially because the picture of the family that stands behind it is in some ways much clearer. That the figure of the fetus can sort of hide some of that, but once you're trying to get rid of someone's IUD, it's pretty clear that where you think their place in society is and what you wish they would do with that place. I do think that there's I think you trace in the book very beautifully how a mask is built up over decades, and I would imagine that would largely pull that mask down fairly effectively. Melissa, does the characterization of throwing stuff at the wall and see what sticks, does that sound about right?
It does sound haphazard. I don't think there's anything really haphazard about this movement, and I don't think that's what Jennifer means. I just think that they are motivated. They are incredibly driven on this particular issue, and interestingly, the nature of the appeal could go in a lot of different directions. There are just a lot of different lines of rhetoric that they can access, and they do. And what is really, I think, interesting about them, and what I think TinyU really puts forth and makes very clear, is that like a snake shedding a skin, they are able to shed what isn't working and pivot to something else quite quickly. So there is a kind of agility and nimbleness to this movement that, regrettably, I don't know has been met with the same kind of nimbleness and agility on the pro-choice side.
Yeah, that might be a good second to last question. I have one last question I want to ask you, but the second to last question, what are things that you wish to see more of among the defenders of choice at this point? What are the things, where are alarm bells not being rung, or the wrong alarm bells rung? Is there anything that our viewers should take away, maybe shift their thinking, or shift their efforts, or shift their donations? Is there anything that you would point to where you think, wow, that obviously Supreme Court justices dying when they do, and the Senate becoming essentially a non-democratic body was not something that advocates of safe and legal abortion had any control over. But are there things that you think could have been done differently, and where change is needed?
So I'll say two specifically. One is sort of specific in terms of like how we buy into rhetoric and what rhetoric we buy into. So, Planned Parenthood earlier this year basically disavowed Margaret Sanger, in part because this narrative about Margaret Sanger and eugenics and the birth control movement had become so pernicious, and it was being associated with a kind of genocide. And so Planned Parenthood issued a very public statement disavowing those earlier ties to Margaret Sanger. And I understand why that step was decided and why they felt it was necessary, but I think they were sort of playing into a narrative that was both historically inaccurate, easily refuted if anyone wanted to sort of just like put forth the historical record. And they could have found, I think, a way to insulate themselves. And instead, they've reinscribed this notion of abortion as eugenics. And I think it's regrettable. I think there are ways that you could have responded to that message without necessarily basically saying, guilty as charged. Let's cut ties entirely, because I think it was really powerful for them to say that, yes, like we were eugenicists at one point, and abortion is a form of eugenics, and we're going to do that. I think the second thing, though, that I would just say more broadly, and this is not necessarily about the court per se, but about the way we talk about the courts. And it just seems to be whenever Roe is in the crosshairs, there's all of this sort of flurry and activity. Roe is going to be overturned, Roe is going to be overturned, Roe is going to be overturned, and then Roe is never overturned. Something happens, and when the something that we expected did not happen, the cataclysmic event that we expected did not happen, instead of really pausing and probing, well, what did happen? We immediately revert to a celebration, like Roe is saved, like we've escaped this, impending doom, when in fact, the thing that happened is actually really bad too. This happened in 2020 with June Medical Services. Everyone was celebrating the Chief Justice as, the person who had saved Roe. Women were knitting him pink hats. He didn't save Roe. He hollowed out Whole Women's Health versus Hellerstedt, which actually gave guidance to lower courts as to how to determine whether there was an undue burden or not. And so, part of this is the media, and perhaps the media not being as well read on some of on some of these developments in order to report them in a way that is clear and accurate. But I think a lot of it is that we want wins. We want to see wins, and that's the only way that we can sort of telegraph that. We can't see the complexity, the nuance, and indeed the Pyrrhic victories that we're being handed.
Yeah, I also would emphasize some of the rhetoric around, especially SB 8 in Texas. I think this comes out of the last 4 plus 6 years, sort of thinking about Red America and Blue America as like totally dissimilar, and this instinct to sort of just cut off the red part, right? And sort of course Texas is backwards. Like there was a little bit of that, and I want to say, I think that the hope for what's going to come next is coming out of Red America, because reproductive justice groups across red states have been working in incredibly hostile environments for a really long time. They've been innovating and strategizing and working to get people abortions, under the worst circumstances. And if anyone has the knowledge about where to go next, it's the people who've been working in red states. They're the ones who we need to be looking for to have a little bit of an idea of where to go.
Yeah, I mean, I think that gets me to my very last question, where I think we've sort of tiptoed around it, but I'd love to sort of close on it, which is about something that Melissa just said. Where we keep expecting this cataclysmic event and then don't notice what actually did happen, which I feel is also a pretty good description of the last 4 years of American history and what they were the culmination of. And I did want to sort of think about the way in which in which authoritarianism, or in which the assault on liberal democracy is part and parcel of this, and makes it difficult for to sort of talk about this issue in isolation, precisely because it comes with all this sort of this broader attack on liberal democracy. And I guess I sort of wanted to think briefly about, I know that the book, Jennifer, came out in 2020, and I was thinking about the fact that, the ability to create, to focus on this figure that you will never meet in real life, but whose advocate you are, who's right, you're there for the fetus, you're carrying its likeness around, you advocate for it, you compare it to a Holocaust victim, et cetera, et cetera. Not you, but the person who's in these movements. It made me think of of course, we didn't see many people marching with fetus pictures, I think, onto the Capitol on January 6th. But what we did see were QAnon folks, and Save the Children, the hashtag that QAnon sort of uses to seemingly radicalize the mothers of American suburbia. Certainly, people in my Instagram feed. It is the same idea, right? You're an advocate for someone who never will make demands themselves, but your advocacy for them in some way justifies the erosion of our system of justice. I kind of wanted to sort of, in this final 5 minutes, sort of ask you this question, like, is this, can you just sort of outline for us, like, what is the role of reproductive justice in this broader move towards right-wing authoritarianism that we're seeing?
Yeah, I think that the idea of saving innocence and victimhood is always a hierarchy in anti-abortion activism, right? That the fetus is always, there could be no more perfect victim, no one more innocent, more because everyone else is born, but children come up as close second, right? And I think that almost anything can be excused in the name of protecting them, and I think that you can see that in a movement that says, we're comfortable with committing acts of violence against abortion providers, right? To save this mass that we, all of these fetuses. I also think in the sort of modern QAnon and a whole host of other right-wing movements, I see a lot of anti-abortion dismissals of elite knowledge and alternative knowledge production. Like the anti-abortion movement's doing that from the beginning, right? They're talking about how people like Alan Guttmacher have sort of pulled the wool over people's eyes, like doctors and social scientists and a whole host of elites who produce knowledge. You can't trust them. And right. They develop their own elites, this whole other narrative of distrust, that the only people you can trust are the people around you, and of course common sense, your common sense is what's true.
Do you mean something like, that apparently ectopic pregnancies can be reimplanted and stuff like that? Is that the kind of, junk science that you're thinking of there?
The basic, the very basics, right? In that they say, why do we stop calling them babies or unborn, right? Who came up with the term fetus, right? That is like the depth of the conspiracy, right?
I see.
And that who came up with abortion reform and abortion laws? It was those, people at universities and right? They're right. Trying to change, fundamentally reorganize the way that people think, and that disrupts what and you can't trust them. You can't trust, all of these people who you're supposed to trust, right? Doctors, lawyers, all these people who are supposed to understand and study. They have an alternative motive. And so I think a lot of the QAnon and right-wing movements are, very much building on movements like the anti-abortion movement, who've been creating alternative knowledge and distrust of a whole host of sort of social authorities for a really long time.
Thank you. Yeah, Melissa, what do you think? Where do you see the contiguities here?
So actually, I had not really thought about it in that way, Jennifer. It's when you say it, it's obvious. And, yes, I think that's like a really spot on and astute observation. I think the other thing I would note, we did not see people carrying photographs of the fetus into the Capitol on January 6th, but what we did see are, a number of people going through the Capitol, looking for Nancy Pelosi, calling her a bitch, talking about Barack Obama. I mean, the kinds of anxiety about the changing model of leadership in the country, I think is relevant to the discussion, to the extent that the early movement to criminalize abortion was about women trying to avoid what was viewed as a natural and indeed inevitable life role, being a mother, and abortion was intended to prevent them from making such a choice. I'm not sure that we're that far in this modern iteration of it, from just the notion that there are women who are transgressing gender boundaries. There are people who are transgressing gender boundaries. I mean, the whole idea of talking about trans inclusion in the abortion fight does not just like create some fissures within the progressive movement. It absolutely infuriates the right to speak of birthing persons. Like we had a whole discussion of this a couple of weeks ago. And part of that, I think, is the sort of inviolability of motherhood as a category that for women to occupy specifically. And the idea that other people would make demands on that label by saying that they too are pregnant and can be pregnant, I think is really interesting. So, I don't think that we can get very far away from the role that sex roles and sex role stereotyping plays in this movement, both historically and presently.
Well, thank you so much. We are at the end of our time, but this was incredibly enlightening. I think we definitely, we covered a lot of ground for those of you who are looking to read more. We have a bunch of things in the chat. This will also be sent to you if you were in attendance today. You'll get some resources that will give you further opportunities for reading. So for now, I just want to thank our two presenters and for their amazing expertise, and again, to recommend all their work to you. It's really absolutely brilliant. And to invite you to our next event, Silenced, How America's Love Affair with the NDA Protects Workplace Predators, with Gretchen Carlson, Julie Roginski, and Ifeoma Ozoma, which will be happening at the end of this month. And I hope to see many or all of you there. Thank you so much.